You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 89. So you want to be a patent agent or a patent attorney? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. A lot of people ask me how to become a patent agent or a patent attorney, and maybe it's because they've been listening to my podcast and they're thinking, ex-party re-examinations, inter-parties reviews, requests for continuing examinations, PCT applications, sign me up. That's what I want to do. I want to be part of this exciting world of patent procedures where the adrenaline doesn't stop. But before you jump into a career as a patent agent or a patent attorney, let's begin with what patent agents and patent attorneys are. A patent agent is a person that's allowed to prepare and file a patent application and be the middle person between the patent office and the inventor. Only two kinds of people are allowed to file patent applications. You either have to be the inventor yourself, or you can have someone do it on your behalf. But you can't just go up to your Uncle Jim to have you help you out with all the paperwork and filing. The only other person that can file on your behalf is a patent agent or patent attorney. Even if you have a regular attorney, such as your business attorney, that you might use for other things, that attorney isn't allowed to file a patent application on your behalf. Let's talk about what a patent agent is first, and then I'll talk about patent attorneys. A patent agent is someone who has passed what is called the patent bar exam. This is an exam that is put out by the United States Patent and Trademark Office, called the USPTO, about all the rules and regulations about patents. Some of it's about patent law, so you do have to know things about what novelty means or obviousness and that kind of stuff. But a lot of it's just about particular rules, like what documents are you allowed to fax to the patent office versus what you have to send them by mail or submit them electronically. It might be about rules about how much time you have to respond to certain kinds of rejections. The exam is pretty much taken by everyone on a computer these days at a Prometrics testing center, and there are 100 multiple choice questions, and you have 6 hours to complete it. Once a year, you can take it on paper if you go to Alexandria, Virginia, but most people aren't going to be doing that. There are 50 questions in the morning, 50 questions in the afternoon, and there are 10 questions that aren't graded, but they're beta questions used to see how people are answering them. But you don't know which questions those are. And in order to pass, you need 70% of those 90 graded questions, so you need 63 of those correct. The exam is open book with an electronic version of the Manual for Patent Examining Procedures called the MPEP, and this is the guidebook for how patents are examined. In paperback, it's over 3,000 pages, and you can be tested on anything in the book. So even though it's open book, if you don't know a good portion of the answers right away without using the book, you're just not going to have enough time to try to look up every answer. And for the questions you don't know the answer to, you're going to have to be familiar enough with the book and patent procedures in general to know where you might find the answer, because 3,000 pages is just too many pages to start doing random word searches to try to find an answer. So you have to pass this exam, but not everyone is even allowed to take the exam. In order to take the exam, you have to have some kind of science or engineering background, which will put you into one of 3 categories. And these are called categories A, B, and C. And it all has to do with what kind of background you have in science or engineering. Category A is the simplest to understand and is the least headache to try to prove to the patent office. If you have a bachelor's degree in most of the sciences or an engineering degree, then you qualify. But not everything qualifies. You can't say that you have a degree in political science and say that's a science. There's a list of 32 acceptable majors, and they're in biology, physics, engineering, botany, chemical engineering, and several others. But the some that you might think, oh, this would totally qualify, they actually don't. If you have a computer science degree, the degree must have some type of special accreditation. So not even every computer science bachelor's degree will count. Now, if you have one of these degrees that counts, you're going to submit an official transcript from your school. If you do have a degree in science or engineering category that's not listed, then you could submit a transcript that might qualify you under what's called category B or C. 2 of the degrees that are listed that don't officially count for category A are in biological sciences and pharmacy. So, just kind of be careful if you think you might qualify because you've taken a lot of science classes. Just make sure it's on some type of list, or you can show that it's enough of a background that they will qualify you. Let's say you don't have a bachelor's degree in one of the sciences or engineering majors that are accepted, but you have a master's or PhD in it. You would think that's even better than having a bachelor's, but it actually doesn't work that way. That doesn't qualify you automatically. You have to see if you qualify under category B or C with enough courses taken that the patent office will allow you to take the exam and be a patent agent. So category B is if you don't have a degree in one of the science or engineering classes, but you've taken a lot of other, science and engineering classes. Now, what classes count and how many you need to qualify depends on the type of class, and all those details are in the USPTO guidelines for how to become a patent agent or patent attorney. It can be a real pain if you have to do it this way because you have to submit your transcript and the official description of the class, and the patent office will decide whether it counts. So it's not as easy as just having a degree from a qualified major, but you can do it. Also, work experience can count, but they're going to be a lot more picky on the type of work that it is, and it's just very difficult to get if you don't actually have the coursework to show it. Then there's the last category, which is category C, where you can be qualified to take the patent bar exam. And this is if you have practical engineering or scientific experience. And the way that you show this is if you have passed an exam called the Fundamentals of Engineering, the FE test, which is a test to see if you know engineering fundamentals. The patent office assumes that if you have passed this exam, then you have enough of an engineering knowledge to be a patent agent or a patent attorney. So if you have the background to take the patent bar, can you take the test yet? Well, not so fast. You're going to have to show some other paperwork that you haven't been convicted of a felony or a crime of moral turpitude, and that you haven't been disciplined by some other professional organization. If you have, it's not saying you can't take the exam, but your situation is going to be looked at on a case-by-case basis. The patent bar has a pretty low pass rate. It's usually between 40 and 50%, and everyone taking the patent bar has an undergraduate degree, lots of advanced degrees, and many are already lawyers that have passed an attorney bar exam. You might have heard the California bar passage rate has been around 55%, and it's considered the most brutal and difficult state bar exam. The patent bar has an even lower pass rate. So what do you do to take the patent bar? Well, you fill out an application and you send it to the USPTO. You supply the documents they want, and then you have to wait for approval to take the exam. Once you get approval, you have 90 days to take the exam. You have to pick a testing center day and time to take your exam. You show up and you take the test. And when you complete the 6-hour exam, right away you will know whether you passed or not. The computer will tell you if you passed. Now, technically, this is just preliminary and not an official pass. But from what I've heard, as long as the testing center doesn't submit information about how it thinks you cheated, then the computer saying that you passed you actually passed, and you'll soon receive an official postcard soon after that. If you pass, you don't know your score, but if you failed, you do receive a score, and you'll see how close you made it. How much it costs? The latest I've seen is that the application fee is $40. There's a $200 examination fee. Prometrics Testing Center charges a $160 testing fee. And then if you pass, there's a $100 fee to register as a practitioner. So in total, we're talking $500 for the whole thing. But these costs can vary, and they might go up in the future. Once you pay your fees and you're registered, it can take a short time to get officially listed as a patent agent. Once you're registered, you can represent inventors and company applicants to the patent office. So everything I've talked about is how to become a patent agent. So what is a patent attorney? A patent attorney is just a patent agent that's also an attorney. So if you're an attorney and pass the patent bar, you're a patent attorney. If you're not an attorney and you pass the patent bar, you're a patent agent. In terms of what patent agents and patent attorneys can do at the USPTO, there isn't any difference. The difference is what an attorney can do outside of the United States Patent and Trademark Office. An attorney can represent you in state and federal court. An agent can't. An attorney can give legal opinions in any business-related matter. Patent agent can't do that. A patent agent can't advise a client regarding patent infringement, only provide a patentability opinion. An agent can't provide an opinion on the validity of someone else's patent or prepare a patent license. You can be a patent agent first and then go to law school, take a state bar exam, and once you pass the state bar, then you're a patent attorney. That's what I did. What's the advantage of one over the other? An advantage of being a patent agent is that you don't have to go to law school, and you just saved yourself 3 years. Something that may be an advantage or disadvantage is hireability. If you want to start your own practice, it's probably harder if you're only a patent agent, because when a client comes to you, they probably want someone to help out with other parts of their invention, like trademarks, or give them legal opinions. So lots of clients want to work with attorneys and not agents. Lots of big law firms will hire both patent attorneys and patent agents, and large companies may have a department of patent agents and attorneys. They don't pay patent agents as much as patent attorneys because they don't have the extra credentials of an attorney. So patent agents may be able to handle the patent drafting, but when it comes to complex legal questions, the patent attorneys will handle those. And that's the basics of how to become a patent agent or patent attorney and the differences between the two. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.